There are several common Googled terms that we as DWI lawyers see and answer as inquiries, and one is, can I get my charges dismissed? Another one is, can I get my DWI charges expunged? And the third is, and the subject of this video is, can I get my DWI charges reduced, or can my DWI charges be reduced to reckless driving or wet reckless? North Carolina does not really care how they do it in other states. So if you're from somewhere else and you've heard the term wet reckless, or if you're from across the border in South Carolina and they've got some other DUAC or driving alcohol appreciably impaired or whatever they're calling it down there. Gosh, I guess back 20 plus years ago when I first started practicing law, they actually amended the statute in North Carolina, they being the General Assembly, where it said that reckless driving is not a lesser included offense of driving while impaired in North Carolina. Meaning that there's not a whole lot of negotiating going on with DWI cases in North Carolina. It's a little bit of thumbs up, thumbs down. Okay, you're either guilty or you're not guilty. Now there are instances, there are occasions where there may be able to plead out to reckless driving if the state cannot make the case to driving while impaired. Normally, though, you would see a DWI charge as well as a reckless charge and start off with, and you're looking at multiple things. So people make the mistake in making an assumption that because you've had no prior record, charges get dismissed, or I'm a good person, can I negotiate this down? And as a defense lawyer, I have to very kindly explain to people that those options in North Carolina may not be the same as what you're used to. It is a very tough law, and there's a reason for that. DWI fatalities are related to impaired driving. There is a correlation between the number of DWI arrests and fatalities both in the state and region and nationwide. There's also a correlation between the higher number that you are and DWI fatalities. I'm the guy that stands next to people charged with murder and felony death and manslaughter due to DWI. I've done it for years, and I'm going to tell you that I understand why the state takes such a position on these type of cases. No one intends to drive drunk, in my opinion. I don't think I've ever had a client that went out and drank and purposely wanted to hurt somebody. I would hope that would never happen, but I can't ever think of a case. The problem is that people confuse not having the intent to hurt somebody as a basis for an equitable remedy, which may include a reduction or a dismissal. These cases are won and lost on preparation and the facts of the case and whether or not the state can make a case against you or not on reductions based on you being a good person or who you know, in my humble opinion. I encourage you to lawyer up, contact legal counsel, call us, give us a ring, 704-342-4357. We're here to help. That's our telephone number, 704-342-HELP. My name's Bill Powers, and I'd love to hear from you.